Hello, I'm David Savage and I'm an attorney from Charleston, South Carolina. Reed Banks has asked that I speak with you concerning my perspective of road construction safety issues. Now, before I do that, let me tell you what I do as a plaintiff's attorney. I represent people that are injured or killed due to the negligence of other people. Now, some of you have a genuine concern for the safety of not only your employees, but the public at large. And for you, I hope that you'll see how I evaluate a case and take those actions necessary to protect you. For others of you out there, you're putting the bottom line above everything else. You're probably reading your newspaper right now or sifting through the calls on your BlackBerry. If so, I look forward to meeting you one day across from a deposition table. Now, every decision that you make in implementing a construction project has consequences. Remember that. Now, I evaluate closely every construction case because, one, there's always substantial injuries or death, and two, invariably, I can always find a violation of the duty imposed upon you under the construction contract. Now, as an attorney, I have to show that you had a duty, that you breached, and it caused damages. That's how I get actual damages, which is fine. But if I can also show that you were reckless, or you exercised a conscious disregard for the rights and safety of the motoring public, I get to punitive damages. Punitive damages are punishment damages. How much does a jury think it will take to make you learn your lesson and not repeat this mistake? And here's something too. Punitive damages are typically not covered on your average commercial liability policy. Those are often damages that you'll personally be responsible for. If there's one lesson that I want you to take from this, it's this. Never let me catch you putting profit over people, because if I do, I can turn that into a conscious disregard for the rights and safety of the public, and I can then get those 12 members of a jury to agree with me that punitive damages are appropriate. Now let's face it, in your industry, you're dealing with heavy equipment. Your workers are often working next to passing motorists. They're often working under grade. They may be working at night. This is a recipe for disaster. Take appropriate action to prevent a problem before one occurs. You typically deal with contracts with governmental agencies like the Department of Transportation. Face it, those entities have attorneys. Those attorneys are drafting those contracts so that liability is shifted from the governmental agency to you. What do I mean by that? Oftentimes, contracts have a number of provisions in there, such as there will be no low shoulders in excess of 2 inches existing at the end of any particular workday. There may be various inspection provisions. They're in there to hold you responsible as opposed to the governmental entity. Now let's talk about something. In a moment, we're going to be talking about Shannon Elwood. Shannon Elwood is dead, and we're going to talk about what happened as a result of her death. But before we get there, most litigation involves 2 defendants, you, the contractor, and the governmental agency. You need to understand that in most states, the governmental agency is limited in terms of the amount of damages that they have to pay. As a plaintiff's attorney, that means I'm going to be looking to you. In many cases, they have what's called joint and several liability, which means that if I can show 1% of negligence on your part, even if the governmental agency is 99% at fault, I can collect my entire damages from you. Here's something to consider too. When a governmental agency knows that they're not on the hook for damages above a certain amount, they're not really taking a case seriously. When they hire an attorney, they're hiring the lowest bidder, which means the lowest priced attorney. That governmental agency is probably dictating how much that attorney can pay on the defense. So if you're looking for an ally at the defendant's table, don't be relying on the governmental agency's defense attorney. Now I want to talk about something that's very important to you, your insurance company. When you're served with a summons and complaint, you send it to your insurance company, and most of the time they hire you an attorney. You need to remember this. That attorney works for the insurance company. That attorney does not work for you. That means that the insurance company will determine how many depositions that defendant attorney takes, how many experts are hired, and whether or not that expert can spend money. An example that I have is in a case that we're going to talk about. In that case involving a low shoulder, the defense hired an accident reconstructionist who did a diagram of the roadway showing where the vehicle was when its tires first entered a low shoulder, coming out of the low shoulder and resulting in impact. That's fine, but the issue in that case was not whether or not that car was in a low shoulder. The issue was what put that car in the low shoulder. And as you'll see a little later, I take this diagram and I turn it against the defendant. Let's talk a little bit about what happens when a case begins. Oftentimes, I'll get a call or somebody will just walk into my office. In the particular case involving Miss Elwood, her father came in. Her father brought a photograph. The photograph showed what appeared to be a newly constructed lane that came to an abrupt termination into a dirt median. There was a long, deep rut alongside the pavement. The second photograph that he had was one of a big gulp cup in order to give perspective as to the depth of the rut. The first thing I do is I send somebody out there to get an independent analysis of the scene. The person that I sent out there was an accident reconstructionist. And what does he do? He photographs the governmental agency trying to fill in the deep rut. With this in hand, I know that more investigation is needed. I will send out Freedom of Information Act requests to the local law enforcement agencies. I will get copies of their photographs. Their photographs will depict the scene of the accident at the time of the accident. Here you'll see you have the dirt median, and if you look at this newly constructed roadway that abruptly ends, there are no raised pavement markers warning drivers that the pavement is about to end. In that same group of information, or that same group of photographs, there was also a photograph of the rut. Law enforcement was kind enough to measure the depth of that rut, 8 inches. I knew that the contract said that ruts or low shoulders in excess of 2 inches were prohibited by the contract. That's a duty that you, the contractor, undertook when you were paid for this contract. Law enforcement also recorded the damages for me. Once I was able to look at the information that I received from law enforcement, I decided that it was then time for me to go to the scene. By the time I get to the scene, it's changed. The cars are gone, and most often the defect has been corrected. What I do is I make sure I understand what the defect was and what the changes were. When I'm looking at the accident photographs, I want to compare those photographs to what exists today. If I find out that there are pavement markings here today that were required at the time of the accident but weren't placed, I know that I need to hire an accident reconstructionist as well as a construction engineer. Because if I can show the failure to place these markings contributed to my client's car leaving the roadway and going into the rut, I've met my burden. Remember, I'm the plaintiff's attorney. I determine how much to spend on a case, and I'll spend whatever it takes. And one final thing, I make sure I have my ducks in a row, my investigation done, and everything in place before I ever serve a summons and complaint. So by the time that you get those pleadings, I'm ready. Once I return from the accident scene, I almost always commit myself to taking the case. That means the filing of a summons and complaint and the initiation of litigation. Now, there are 2 things that I see defendants do that cripples their case. Number 1, they send people to depositions that are unprepared. They know nothing about the contract that they were supposed to fulfill. If you're going to send an employee to a deposition, make sure your defense counsel tells them their role in the case. Make sure they're familiar with the documents that I'm going to show them. The second mistake that I see is when a defendant sends somebody to a deposition who doesn't take it seriously. Remember, someone has died or has been severely injured. If that person is not serious at a deposition, I will expose that. Now, you remember I said that as a plaintiff's attorney, I'm not limited by my funding? Well, I've gone out to the scene. I see how that accident has occurred, and I will actually take the exhibits of your defense expert and use them against you. Do you remember that overlay that the defense expert did showing the car once the wheels had gone into the rut? Well, I take that and I'll make my own exhibit. What I've done is I've hired the services of an animator. He's taken the testimony of the witnesses as well as the scientific drawings of the engineer hired by the defense. You'll see the shadows of the car. and my animator will take a car and run it along the parameters of the defense expert showing how the accident occurred. Once I have shown that my science is correct, I will then go and show what my client saw at the time of an accident. In this particular case, the witness indicates that my client was driving in a right-hand lane. That lane ended, and as my client was attempting to move from right to left, her wheels left the pavement and entered a drop-off. My client then oversteered, which is a natural reaction, and made contact with the witness's car. Now listen, remember what I said? The law is what I can get 12 people to agree with. I'm a storyteller, and nothing tells a story better than a visual. You've seen what I produced. Well, let me show you what that defense expert produced at trial. He merely took his drawing and placed an arrow as to where he thought the vehicle was coming from. When you have two exhibits like this competing, which exhibit do you think is going to carry the most weight with the jury? So as I conclude, there are two things that I want you to take away from my talk. Number one, don't allow me to characterize this case as one where you're putting profit over people. Because if you do, I'm going to hold up a picture like this in closing statement to the jury. And they're going to see the woman that's dead, and they're going to see my client sitting next to me. The second thing that I want you to remember, hire your own attorney. The attorney that the insurance company is going to provide for you represents the insurance company. Your private counsel can ensure that cases that need to be settled are settled at the appropriate time, relieving you of any excess liability. I hope I've helped you, and in helping you, what we're going to do is ensure that your employees remain safe and the public at large remains safe. Have a good day.